What's up, guys? Brian Fell Law Group, PLLC, here with your Florida Law Weekly case update. Got a six-pack of cases for you this week, so I'll try to get through them quickly. They're all pretty good, though, so let's get right to it. First case is Winegar versus Winegar. It's out of the 4th DCA. Has to do with a multitude of issues. First is business valuation, and this goes for valuation of really any asset in a dissolution of marriage proceedings. The trial court cannot split the difference. So if one side testifies or presents evidence that the value is 100 and the other side says 0, the court can't just say, okay, I'm going to value it at 50 and split the difference. That's essentially what the court did here. That was an error. The other error was that it failed to calculate the alimony arrearages based on undifferentiated support. So apparently the parties did something where they did a agreed order that we're going to have, husband's going to pay a certain amount each month as undifferentiated temporary support. Undifferentiated meaning not alimony. We're not saying it's alimony, we're not saying it's child support, it's just total support. So the court had to basically go back and break it down and say what was the amount that was for alimony, what was the amount that should have been paid for child support, run the guidelines, and then determine if there's any arrears. Another issue in this case was a brokerage account that was used to pay down, that was used as collateral to fund some, with a loan that was used to fund some marital expenses. Has to do with commingling and non-marital assets. So this is a good commingling case, basically, for anti-commingling, let's say. So basically the court said the fact that a loan was pledged against non-marital assets in order to fund marital expenses and paid down with marital funds does not convert the entire remaining asset, which this was a brokerage account, doesn't convert the entire brokerage account into a non-marital asset just because you use marital funds to pay down a loan during the marriage. Apparently you could clearly see the amount that was paid down from the marital assets into the non-marital account. You could see it being paid down, you could trace it, and so the court said, we're not going to make this a complete commingling, fishbowl case where the ink goes into the fishbowl and it taints everything. No, we're going to say that we could trace this back, and so we're going to keep the non-marital character of the brokerage account. Next case is Carter versus Carter. This is out of the 4th DCA. This one I thought was interesting for the reason of when you're dividing marital assets, don't forget to divide the personal property, photographs and videos, sentimental value, things like that. Apparently, the husband was being kind of a jerk and keeping all the family photos and videos, which included videos of the wife's mom, who unfortunately passed away. And so the trial court refused essentially to distribute those. But if somebody asks for the photos and videos to be distributed, that those are marital assets if they're acquired during the marriage. And so those should be distributed just like any other asset. So keep that in mind. Next case is a stalking injunction case. This is Carvajal versus Ferretti. This opinion went into detail. It's a good stalking and harassment case, basically showing when harassment is not sufficient. So for stalking, you need 2 different instances of harassment, and each instance of harassment requires a course of conduct. So it can't be like isolated incidents, which is apparently what happened in this case. It was sort of, this is like the new girlfriend against the former wife. And really it's the former wife was trying to get an injunction against the husband's new girlfriend. And apparently the girlfriend was texting the wife, sending WhatsApp messages, things like that, to the wife, which were not pleasant. They were nasty, things like that. But there weren't 2 separate instances of harassment. And the court really goes into good detail of saying, when is harassment possible and when is it not. It's really not meant for a situation where there's just general disagreement and even nastiness, even like straight up nastiness between 2 parties for harassment and stalking. It's got to be more than that. It's got to be something that causes substantial emotional distress under an objective standard, and it's got to be for no legitimate purpose. So for example, in this case, the girlfriend was texting the wife about child support, Well, I mean, maybe the girlfriend should have stayed out of it, right? It's none of her business, but it's not for no legitimate purpose. This isn't like a random stalker or a random person harassing somebody for no purpose. So it really is a high bar. You need to have at least two different complete instances of harassment in order to get one of these stalking injunctions. And it really has to be something that a reasonable person would cause them substantial emotional distress, not just nastiness. So good case for that. Next case is Macdonald versus Macdonald. This has to do with costs of a guardian ad litem. A lot of cases, somebody will file a motion for guardian ad litem and say, hey, split the cost 50-50, or one party should pay for 100%. Well, what this case stands for is, you really need evidence of ability to pay. So, and this was a temporary relocation case. So a lot of times you don't have complete information, which is fine, but the court said, you have to base it off of whatever information or record evidence that you have of ability to pay. It can't just be like randomly like, okay, you want to relocate and get a guardian ad litem, well, you have to pay for 100%. No, you got to have, why are you making this person pay for 100%? It's got to be based on the actual finances. And that can be based on, the financial affidavits at the time, whatever it is. And you can say subject to reapportionment at a later date, but it's got to have some record evidence of the ability to pay. Next case is Rodriguez versus Rodriguez. This has to do with when you're moving to vacate a recommended order of a general magistrate, you have to provide the transcripts. Yes, everybody knows that or should know that. But what the trial court did here was flat out summarily deny the person's motion to vacate simply because they failed to provide the transcripts. And the court said that was an error. Even if they don't provide the transcripts, maybe they provided most of them, maybe they provided, the material ones, maybe they substantially complied. That's what the court said. Maybe they substantially complied with the requirement to provide all the transcripts. So you can't just summarily deny it. You have to have a hearing and see, what is the reason for them not having the transcripts and things like that. So you can't just say, oh, they didn't provide the transcripts, denied. No, it's got to be something a little more than that. Last case is Thomas versus Department of Revenue. This is good for obligees. So if you let's say you're a mom or something, somebody that requires child support, you go to the DOR to get your child support order. DOR gets an order, but you disagree with it because you're like, hey, that's not high enough. I need more money. His income was higher, while my income was lower. If you're the obligee in one of those situations, you really cannot appeal. The same way that an obligor or the DOR, the Department of Revenue, they can appeal to the District Court of Appeal. But as the obligee, the person receiving the money, you cannot appeal to the District Court of Appeal. Your remedy is to file some sort of action in the circuit court, maybe some sort of motion to supersede or something like that, or petition to modify it. But you cannot go directly to the District Court of Appeal the same way that an obligor or the DOR can. All right, guys, that's it for this week. Happy Mother's Day belated to all the moms out there. Hope everybody has a good week. Take care.